Good morning, good afternoon, and good evening to everyone. We welcome you to Lawyers Across the Globe and Around the Clock for the Rule of Law, an unprecedented Rule of Law 24-hour webathon. This panel, presented by the Inter-American Bar Association with the collaboration of our friends at the Paris Bar too, it's going to address, the topic of business and human rights developments from the UN principles to the due diligence laws. We are one of 12 diverse panels being offered for 24-hour continuous, for 24 continuous hours by bar associations worldwide to celebrate, address challenges, and defend the rule of law, all in this YouTube channel. The rule of law is society's legal underpinnings, guaranteeing human rights and creating economic opportunity and development. And we lawyers are often the first line of defense. Though the rule of law is not merely the stock and trade of lawyers, it is our core value. The universal commitment of the world's lawyers to the rule of law inspired us and many other law associations to join forces and launch this first of its kind, second edition of the webathon. We are proud to be part of it. We just come from listening a great panel, that preceded us about a case for global climate justice. What is the dream goal and what are the odds in achieving it? And it was organized by AIJA in collaboration with, the sort of Emirates Bar. And the important thing is, AIJA's organization, International Association of Young Lawyers, and it is important actually to have their voice, keeping the dreams, talking about the dreams, and hopefully also, helping us make them reality and increasing the odds of achieving it. We would like to, make a disclaimer about the panels, and it's that the views expressed during this event are those of our panelists and don't represent either of the institutions organizing this event. And that applies to us also. I will, refer to the theme of the panel. We know that in 2011, the United Nations Human Rights Council endorsed the guiding principles on business and human rights, developed within the UN Protect, Respect, and Remedy framework. That informed the general principles, which reflect that the guiding principles are grounded in the recognition of the state's obligation to respect, protect, and fulfill human rights and fundamental freedoms. The role of business enterprises, which are required to comply with all applicable laws and to respect human rights. And the need for rights and obligations to be matched to appropriate and effective remedies when breached, which in fact, or in turn, require a system that enables access to justice. The guiding principles apply to all business enterprises. Guided by this framework, the panel will examine the important role of states and business enterprises in protecting human rights and upholding the rule of law, as well as the challenges in ensuring a right of access to effective remedies. The speakers will also explore the evolution from the UN principles and self-regulation mechanisms and national plans to national due diligence laws, such as the novel French Duty of Vigilance Act, passed in 2017, and the recently enacted German Due Diligence Act, as well as the global impact of the EU's approach and the current draft of the EU resolution on business and human rights. I just would like to also, thank everyone for attending this panel. Thank all the organizations that had been, partners in organizing this event, like the American Bar Association, the UIA, AIJA, the Law Society of England and Wales, and our teams behind the scenes, including the IABA teams, and all our panelists. Without more, I'm going to introduce, our, friend and colleague, Stéphane, who is going to help us moderate this panel. Stéphane de Navacelle, of Navacelle practices corporation litigation, predominantly in criminal law, regulatory, internal investigations, compliance, complex litigation, and arbitration. He's a former member of the Paris Bar Council, bar disciplinary judge, and he is the bar appointee for influence through law. And he's been part of this initiative, which is really one of its kind, even though we are running the second edition. And it has been with our team, since the first, rule of law webathon in 2021. So we're very, honored and happy to be working with him here and having his support. Stéphane, without more, I'm giving you the floor. Thank you.
Thank you so much, Lourdes. It's wonderful to be back again for the second edition. Unfortunately, I think over the past 12 months or so, we have not seen considerable progress in the rule of law globally. Quite to the contrary. And as you stressed it out in your introductory remarks, us lawyers, both in-house, on the bench, and at the bar, have an obvious key role in raising awareness and advising our clients, internally, or when rendering decisions, judgments, of explaining what really is at stake here, and what does the rule of law mean? Everyone is in favor of the rule of law, including the most vicious dictators. So, is it just a fancy flag, or is it more? There's more substance to that, and I think it's great that we can all come together globally and focus on a few of those issues. So I'm going to introduce our panelists who've gotten up early or stayed up late, and hopefully we can have a lively debate. You should use the Q&A part of the YouTube channel, which we will see on our screen. And as the moderators, Lourdes and I will pick up the questions and put them to the moderators. So please, help us stay awake, and we look forward to this discussion. So we're delighted to have Emily Sims from the International Labour Organization based in Geneva, Switzerland. Emily is a senior specialist in the ILO program on multinational enterprises and social policy, and manager of the ILO help desk for businesses. She has been involved in drafting of the labor component of various key CSR instruments, and has provided technical assistance to a range of industry multi-stakeholder initiatives, as well as providing guidance to individual companies. Her work is focused on promoting sustainable and responsible investment. So here you have a key issue, or a variety of key issues for corporates and for those who are, maybe you can call them market watchers, or who hold those corporates accountable. And we look forward to hearing about that. We will then hear from Louis, my friend Bernard Buchmann in Paris, Louis is a member of the bar in Paris and New York. He was for over a decade a partner at Fields Fisher, and he created his own firm in 2019 called Lex-Force. It's an arbitration and mediation boutique here in Paris. He logically is an arbitrator and mediator, accredited by the World Intellectual Property Organization, the AAA ICDR, the Polish Arbitration Court in Warsaw, and he has been recognized repeatedly by a number of ranking and market viewers throughout the years. And he is a native French, English, Poland, and Italian speaker. And he has a command of the German language. And of course, he also is, as we all know, a captain in the French Navy. So great to have you on board, Louis. Hans Christian Zagler is an attorney in New York and Frankfurt. He's an arbitrator, a certified mediator, and he founding partner of Zagler Rechtsanwalt in Frankfurt. And he has been involved in numerous M&A transactions, joint ventures in Germany and abroad, has worked extensively as an arbitrator, FCIR, and he also is a certified mediator. He is a European attorney in the Czech Republic and registered foreign lawyer in Hong Kong. He serves in multiple boards of German and international companies and will give us a great perspective, both from inside and as an advisor. And it's wonderful to have you, Hans Christian, here this morning or evening. Lourdes is I don't know if I can call you a founding member, but a great proponent of this initiative and has been since the outset. Lourdes is admitted to the DC and New York and Lima bar. She's served in multiple leadership roles in our lawyers organization, keeping us disciplined and moving forward. Both as a Secretary General of the Inter-American Bar Association, leading the Inter-American Bar Association DC chapter, represented the IABA at UNCITRAL working groups, and has also been, amongst many other important functions, an advisor to the Peruvian Minister of Justice in leading the design of an anti-corruption project, supporting the development of business and human rights plans, and working on judicial reform. So it's wonderful to be here to co-moderate this panel with us. Thank you so much. And so maybe we can start our conversation. Again, everyone listening can make this as lively as possible by using the chat conversation, and we'll make sure that we will address the questions that are put to us. And I'm going to pass the floor to Lourdes to introduce the first theme.
Thank you. Thank you, Stéphane. I guess we will just would like to just emphasize the conversation of the panel and the reflection that the panel will have, as we already said, in terms of the business and human rights. One aspect that it was implied probably in the presentation is the fact that we will also address, the impact on, economic and social development. And in that regard, Emily will help us with that. And she have, a unique combination of legal and economic background that is, perfect for this topic too. So without more, I will give the floor to Emily. Thank you.
Thank you, Lourdes. I'm going to share my screen. I apologize for using slides. It's a little pedantic, I know, but because I am speaking actually about the guiding principles, which are not ILO's instrument, I really want to make sure I'm not misspeaking. So I'm going to share my screen with you now and explain.
Could you speak up louder,
Sure.
Emily?
Can you hear me better now?
Yes, thank you.
Is it better? Okay. Can you see my screen? It's okay? Yeah?
Not yet.
Not yet. Okay. I thought I had shared it. Share screen. Okay. There we go.
Wonderful.
Okay now? Okay.
Yes.
Okay. So I'm going to explain to you just briefly the basics, especially from a point of view of law, of due diligence as it's set out in the UN Guiding Principles on Business and Human Rights. So just going to have to close that. So first thing is the concept of due diligence itself, which you're probably familiar with as lawyers, but it's the building block of the UN Guiding Principles concept on due diligence. And it's defined as reasonable steps for to be taken by a person to avoid committing a tort or offense, and a comprehensive appraisal of a business undertaken by a prospective buyer, especially to establish its assets and liabilities and evaluate its commercial potential. My husband, who's a professor of finance, basically describes it as no excuses for not doing your homework. And that same concept has now been imported into the world of human rights as businesses are undertaking their business activities, knowing who they're doing business with, not just from a commercial point of view about quality, delivery, et cetera, but also from a social development point of view. So the UN Guiding Principles have three pillars. I won't describe them in detail, but they're kind of laid out here. But what you really need to understand is it's not just a duty, a due diligence duty that sits by itself. It's contextualized. And the first and vital pillar is the state duty to protect human rights, which means that from a legislative point of view, they need to get their act together, not only have good regulation, but actually enforce it, which I can tell you from working in the ILO is one of the main issues. It's not usually the law, but the lack of implementation of the law. But that it's not just a matter of legislating, because companies take their cues from a whole range of policies that government sets out at the national and international level, which either reinforce that message, you must take human rights seriously as part of an integral part of your business operations, or completely undermine it, for example, by awarding a tender to the cheapest bid, knowing full well that that very low bid that was put in makes it really, really unlikely that they'll be able to respect all the rights of the workers in the community in which they're going to carry out that contract, as just one example. So they need to get their act together on their side, the regulatory and policy framework and how it needs to be coherent. But they also need to support companies. And we'll get to what companies need to be doing in Pillar 2, but there's a whole environment in which they can help accelerate and underpin the costs, the complexity, the steep learning curve that companies face when they're doing due diligence. As Lourdes and Stéphane mentioned, my whole job is in the process of companies doing their due diligence, lots of questions come up at the various stages, and I'm answering those questions and trying to support them. But I'm only one person, and ILO is only one institution, and there's a whole range of issues out there. And the costs involved in collecting information, et cetera, to the extent that governments can support companies by flattening the learning curve, especially for smaller companies, but also creating public goods like databases of information An example of that is the US State Department's Human Rights Index that a lot of companies use as part of their due diligence. Those are really helpful for companies. It's not that companies are just allergic to human rights. It's that it's complicated, it's out of their comfort zone, and it's very labor intensive in many respects. How can we minimize that burden? But also that they need to look at themselves as state actors, state-owned enterprises, when they are purchasing as consumers, as buyers. The biggest buyer in any economy is the state. So having policy coherence in that respect as well. So that's the bigger context in which Pillar 2, which focuses on the specific obligations of particular companies, exists. And so it's a concept of doing no harm, avoiding the rights, infringement of rights wherever they operate. And by operate, meaning their own operations, but also where they have a direct link to other companies and their operations. And the second square and smack in the middle is the concept of due diligence. It has a duty to respect all minimized, a minimum, all internationally recognized human rights expressed in the International Bill of Human Rights and the ILO Declaration of Fundamental Principles and Rights at Work. And then from that, it follows that you have a due diligence duty to identify, prevent, mitigate, and account for their human rights impacts. And we'll unpack that a little bit more. But then it's beyond the duty of due diligence, but it's very much linked to it is access to remedies. So you have to also understand that there's this third pillar, meaning when a violation occurs, it's not just a matter of avoiding them, but when they pop up anyway, despite your best efforts, or sort of a historic legacy before you've undertaken your due diligence, there's a requirement of access to remedy, and there's a public government responsibility, a private business responsibility, and then there's an encouragement of overlap and collaboration between the two. So the 4 steps of due diligence are assessing actual and potential human rights impacts. That's partly done. Usually the first stage is desk reviews, then screening of your potential business partners, but then also doing like on-site visits and so forth to have a good understanding of at the micro level. But zooming out at the macro level is doing a mapping of all your business partners, which is one of the most daunting tasks for any company, but it's important to undertake that. And then the second step is integrating and acting upon these findings. So it's not enough to just know where your potential risks are, but what you're going to do as an operational level to set up systems that are going to prevent and mitigate those risks and respond and support as necessary your business partners when those problems arise. And then you have to track responses, because any manager will tell you if you can't monitor it, you can't manage it. That's a mantra of any manager, especially in the supply chain context. And so having a system in place that tracks responses is really important, because you also need to be constantly revising and updating your system. And then the last part is going to transparency and holding yourselves to account, not in the legal sense, but in the, not necessarily in the legal sense, but in the sort of ethical sense, committing yourselves publicly and then communicating how you are doing on that public commitment is an integral part of the whole pillar 2 of the UN guiding principles. So just a few important details for you as lawyers to understand is that human rights due diligence, it should cover adverse impacts of your own activities, because there are companies that are operating in 100, 160, 180 I worked with one company that's in 180 countries around the world. That's a lot of countries to keep track of, but that's their own operations. But also where you are directly linked to other businesses. That's the wording from the guiding principles. But you should be aware that there is a lot of pressure and a lot of commitments, especially from other instruments such as the OECD Guiding Principles, that it goes beyond, do you have a commercial contract with this enterprise? So for instance, further up the supply chain, there's problems right now in Uzbekistan, Tajikistan with cotton. Any of your businesses that are doing business indirectly with Uzbekistan and with countries that have problems with forced labor, in this case, forced child labor in cotton production, it's not enough to say, well, I'm buying it on the open market, knowing that that one of the main sourcers is from one of these countries. Even if you don't have a direct commercial link, there's an expectation that you're doing your due diligence around avoiding situations that would put you in contact with especially egregious human rights violations like child forced labor. The other thing you need to understand, though, is that the UN Guiding Principles are not a one-size-fits-all approach. It recognizes that there are very large multinationals with huge staffs just dedicated to social questions, such as labor issues or community rights issues. And then there are small companies that have no staff whatsoever dedicated to this, and it doesn't expect the same response from a business of every size. And as our other speakers will explain, that also gets reflected in defining the scope around legislations that is mandating reporting. The other key thing to understand is that it's not a one and done thing, and that your client can just tick, yeah, I set up all those things, I'm good, I can check all those boxes. It's an ongoing process, and it's actually built on the concept, the general concept in business of continuous improvement. So that monitoring is not just monitoring to make sure everyone's doing their job, but looking for ways that you're less than effective, less than efficient in your own operations, and the impacts on those rights holders that are influenced or are affected by your operations directly or through a direct link, commercial link, that you should be tweaking that and making improvements as you go along. Who to involve? That recognizes that these are complex issues and encourages drawing on expertise, both internal, like I said, companies often have whole departments dedicated to this, but also independent external human rights expertise, and that's fine, although there should not be an offloading of your responsibility. And that's one of the great temptations of companies, is to just say, I will subcontract everything, and that way it will insulate me and create a sort of arm's length transaction. It's not my problem if the commercial auditor I hired failed to find something. It doesn't really insulate you from that liability. So if your client's instinct is to go the subcontract route, that's not the ideal, and it's actually not necessarily going to achieve those aims of insulating themselves from liability or responsibility, I should say. And the second point is that these rights holders can speak, and they have views and they have concerns, and as part of a broader reinforcing a democratic representative process of allowing people to speak for themselves and listening to them and taking their considerations seriously on board, although that doesn't mean your client is going to have to accommodate every concern. One of the fundamental principles is that they should be engaging periodically with the relevant stakeholders and prioritizing the views of the stakeholders based on who is also an actual rights holder. So an NGO with a general interest, that's great, and they might have very valuable and critical information, but that's different than the community rights holder who is talking directly to you about how they're affected. So you need to also bear that in mind. Not all stakeholder views are equal. Tracking. Again, you can't measure it, you can't monitor it. So it should be based on appropriate qualitative and quantitative indicators. This is a challenge for every company. If any of your clients have worked with, for instance, the GRI, the Global Reporting Initiative, they'll tell you how complicated it can be. And I am very, very sympathetic to that problem. They can maybe work on it in a bite-sized approach, prioritizing certain critical elements first, and then working to the more nuanced kinds of rights that are harder to quantify, such as non-discrimination. And then draw on feedback from both internal and external sources, including stakeholders. What you need to know is that there are other instruments that may be affecting your clients, in particular if your clients are based in a OECD member state, because the OECD has updated its guidelines in 2011 directly to focus on the UN Guiding Principles and the implications for the OECD guidelines and the guidance and expectations that governments should have, OECD member state governments should have for their companies operating abroad. And so your clients may find themselves the subject of a complaint brought to a national contact point, an OECD national contact point. So that's another context in which you need to keep in mind the implications of the UN Guiding Principles. There's also the update of the ILO's instrument. As I guess I didn't mention, a core focus in the UN Guiding Principles is the ILO Declaration on Fundamental Principles and Rights at Work, which concerns forced labor, child labor, non-discrimination, freedom of association, and collective bargaining. And so they are really important for your clients because they are material to no matter what activity they're undertaking, because those are not sector specific or country specific, they're universal. So the ILO's instrument that talks to companies is actually this sort of sister instrument to the OECD guidelines, but applies universally. It was also updated, but because workers are unique, they are stakeholders and rights holders, but they are also integral to the operations of companies. They're the one human rights right holder that sits in the company as opposed to in the community or a shareholder with their rights, but they're not human rights or other rights holders. They are in the company. They're there on a daily basis. So the M&E Declaration, what the ILO did is they thought about the implications of due diligence and the unique position of workers as rights holders. And they came up with a slight difference, or not a difference, in the Office of the High Commissioner for Human Rights was involved in updating the M&E Declaration, but a tweaking of due diligence for the specific labor context. And it says that the process should take account of the central role of freedom of association and collective bargaining, as well as industrial relations and social dialogue as an ongoing process. Again, that's because they are sitting right there. The management sees them on a daily basis, interacts with them on a daily basis, and partly also because the whole concept of good industrial relations is integral in strengthening those enterprises through productivity improvement, niche development, et cetera. They are an integral part of that as well. And so having a very effective due diligence system that takes into account those costs I mentioned before, industrial relations is foundational to that. So that's why they updated the M&E Declaration to reflect that. There's also a slightly more topic specific and for purposes of law, it's very much a focus of a lot of laws addressing due diligence. It's the update to the ILO Protocol that updates the Forced Labor Convention, and it specifically references due diligence. It's the first time an ILO instrument started to speak about due diligence in incorporating the UN guiding principles. And it calls on governments to, it requires governments who have ratified the protocol to support due diligence by both public and private sectors to prevent and respond to risks. And it specifically calls out public sector, which is normally we don't distinguish public and private sector. Our standards are globally applicable, but it specifically focuses on public and private sector to clarify in line with the guiding principles. We're also talking about state-owned enterprises. We're also talking about governments as purchasers, as buyers, and their market influence on these private sector actors. So that's sort of and that the protocol was ratified so far by 59 governments. So your clients may wish to keep that in mind as well. For your clients, a really important thing to direct them to, especially if they're OECD based, they're based in a country that's a member of the OECD, is OECD guidance. They have wonderful sets of guidelines, one general, many sector-specific ones, and they will be, again, mentioning the national contact points, but also simply as good practice. They're really important references for your clients, and they were made with input from companies as well as other sorts of stakeholders. There was very large multi-stakeholder processes involved in developing of all of these guidelines, and the ILO and other UN agencies that are looking at different elements of human rights also contributed. So they're very, very helpful, and they're very detailed. Just a list of different legislation that you need to be aware of that have been incorporating due diligence in national law as reporting requirements, sometimes with liability issues concerned, that you should keep in mind. I'll skip this slide just because of time, but one of the things I wanted to mention is that you should bear in mind that these are all very much linked to trade agreements. A lot of the impetus for legislation and a lot of the teeth in legislation or government policies to support due diligence come in. For instance, the US government is extremely aggressive about impounding any products being imported, which they've identified being used by forced labor. And it will be difficult, and the onus will be on your client, if your client is the business that's trying to import those goods, to get them back, just as one example. So a lot of the work that ILO does, and I do in particular, is not just around due diligence as it relates to companies, but government policies that are trying to reinforce the notion of the responsibility of companies in the area of due diligence. I'll stop there. Thanks. I don't know if I stopped sharing my screen. Yeah, I think so.
I think it's my turn to speak.
Yes, Louis, and thank you. I want to thank Emily for the great presentation, and we will have opportunity to go more into the topic during the Q&A. Thank you, Louis.
I just want to underline one sort of general rule that Emily stated, which applies to many issues. No excuse for not doing your homework, and I think that's a great sort of non-legal rule. And it really applies to the fundamental change that is expected from companies globally, and certainly those that have ties with France, that turning a blind eye, the willful blindness, the, call it whatever you want. Not doing your homework is no excuse. I'm going to keep that one.
So good morning, good day, or good evening, wherever you are. And thank you to the Inter-American Bar Association for having me on this panel. Emily Sims just presented excellently the United Nations Guiding Principles, which were adopted in 2011. And as she said, those guiding principles are aspirational, but not coercive. However, France, less than 6 years after the adoption of the guiding principles, has transformed this soft law into hard law by adopting in March of 2017 a law on the duty of diligence for companies and buyers at the top of value chains. We call them les donneurs d'ordre. And this law is really a first of its kind because it has given teeth to the guiding principles. And I'd like to present briefly this law and maybe give an assessment of it 4 years after it came into force. And then I'll stop and my colleague Hans Christian Salger will talk about the new law in Germany, also on the supply chain. And then perhaps I'll say a few words about the recent developments at the European Union level. So starting with the situation in France as from this law of 2017. First of all, which companies are concerned? I think it's important to realize that this is meant to the scope of this law is for larger companies. That means those with more than 5,000 employees in France, or those with more than 10,000 employees worldwide, including the company's subsidiaries. So what does a duty of vigilance, as we call it, require? Well, it follows, in fact, the guiding principles of the UN, and it's about conducting a due diligence exercise over the company and its subsidiaries, their suppliers, subcontractors, only the subcontractors with which there is a steady commercial relationship. And the purpose of this due diligence exercise is to identify the risk of human rights violations. For instance, violations of hygiene, health and safety regulations for the staff, of harm to the environment. And this due diligence exercise will produce, it's in fact a risk mapping exercise, and it'll produce at the end of the day a vigilance plan. So the company is responsible for drafting this quote unquote vigilance plan, which must include an analysis of the risks it has identified, and also actions to prevent or mitigate them. And also to set up permanent procedures to assess the implementation and the effectiveness of the plan, and to alert the company in case of non-compliance. In other terms, to set up a whistleblowing possibility, of which Stéphane de Navacelle here is one of the foremost experts in the world. And then it's not enough to draw up this vigilance plan. The companies have to report yearly, year after year, on the implementation and effectiveness of the vigilance plan. So this report has to be made public, and the way to in France at least, to make it public is to attach this report to the yearly management report, which is filed with the company's registry. So in fact, it is accessible to the general public. And a good vigilance plan, and there are several of them out there, may be reused by a whole industry. So if a competitor in a given industry sees that its competitor has devised a very good vigilance plan, there's no exclusivity on it. On the contrary, this competitor and several others will probably adopt a very similar or identical vigilance plan. So this has a snowballing effect. And in 2019, already that is 2 years after the coming into force of the French law, 83 vigilance plans were already publicly available. Now, what remedies? What remedies if the duty of vigilance is not complied with? A plaintiff must put the company on notice to comply. If the notice to comply is left unsatisfied for 3 months, then the plaintiff has an option. Either the plaintiff is a victim of the harm, a direct victim, and then he or she has standing to initiate a civil liability action against the company, provided, as always in a civil law system, that the causal link may be demonstrated between the harm complained of and the company's shortcomings. And the victim damages will be limited to compensating the harm suffered, which would have been averted had the right measures been adopted and implemented by the company. Now, if the plaintiff is not a victim of the harm, for instance, a union, a trade union, or a non-governmental organization, an NGO, then it can seek to obtain injunctive relief by way of a court order, possibly including penalties for each day of non-compliance. The records show that as far as the French law is concerned, no civil liability action has been initiated at all based on that law since its entry into force. So it's the other route that was taken, the seeking injunctive relief by way of a court order. In 2019, 7 notices to comply alleging defective or insufficient vigilance plans were sent to various companies, like our largest electricity and energy utility, EDF, to Suez, another very large company, to Casino, a very large food retailer, Teleperformance, XPO Logistics, which is a transport company, and Total Energies, 2 such notices to comply for the latter company. 2 separate court actions were actually started against Total Energies. In October 2019, one action was started by 7 NGOs in relation to 2 oil-producing projects in Uganda. The plaintiffs chose to sue Total Energy before the summary action judge of a civil court. Total Energy contested that jurisdiction, saying that the action should have been brought before the summary action judge of a commercial court. And the civil court indeed ruled that it had no jurisdiction, and the plaintiffs appealed against that ruling, and the Court of Appeals of Versailles upheld in December 2020 that ruling, deciding that the jurisdiction should be that of a commercial court. So now the plaintiffs must decide whether they want to sue again before the summary action judge of a commercial court. And the second action against Total Energy was started in January 2020 by 14 local authorities and 5 NGOs for failing to take appropriate measures to mitigate the effects of its actions on climate change. That action is still pending in the first instance. I promise to give you a honest provisional assessment of the law's impact 4 years after its entry into force. The main criticism that can be leveled against the law is that many vigilance plans are still succinct. There is no official government monitoring body supervising the law's implementation. So enforcing compliance with the law has proven to be quite complex, as it is often difficult to check whether a company falls under the scope of the law. For instance, the thresholds about the numbers of employees, which I mentioned at the outset, need to be met in two consecutive financial years. And if you fall back to less than the threshold, then you can say, I'm no longer within the scope of the law, so I don't have to report, or I don't have to devise or to implement a vigilance plan. Also, remedies for victims lag behind what was intended by the law. So two NGOs, Terre Solidaire and Sherpa, created an online searchable database to access the filed yearly reports. You can find this on the internet by just typing radar of the duty of vigilance, radar du devoir de vigilance, and you'll find the reports of those two NGOs, and they also report on the status of the actions that were undertaken to actually against the companies that I just mentioned. The actual benefit of the law, I've been quite critical about it, but perhaps I should say a few good words about the law, is that companies which fall under the scope of the law have become attentive to the law's obligations, and for the most part are compliant with the law's obligations. It is also a fact that in 2019, so 2 years after the French law, the Netherlands adopted a similar law on the supply chain, and Germany has now adopted one as well. And Hans Christian Salger will present that law in a moment. Belgium has also considered such a bill, but it was put on hold because of EU level developments, which I'll mention after the presentation of Hans Christian. So let me stop here because I'm losing my voice. Thank you.
Thank you very much, Louis. I guess it's my turn now. Mm-hmm. And indeed, as you had already mentioned, roughly a year ago on July 16 last year, to be exact, the German Parliament, the Bundestag, and also the upper house, the Bundesrat, have passed the so-called Act on Corporate Due Diligence Obligations for the Prevention of Human Rights Violations in supply chains. In German, it's actually one word, very long word, Lieferketten-Sorgfaltspflichtengesetz, terrible, which endeavors to have private corporations and companies, rather than states, governments, and legislators, protect human rights worldwide. Subject to the Act are enterprises that have their central administration, their principal place of business, their administrative headquarters, or their statutory seat in Germany, and regularly have at least 3,000 employees in Germany, whereby employees posted abroad are included, as well as enterprises that have a branch office in Germany and normally have at least 3,000 employees in Germany, so rather large companies. The number of employees will be reduced, however, to 1,000 employees from 1st January 2024 on. The Act, and that's a short comment, falls short of the EU Commission's proposals for a directive presented end of February this year, insofar as the European proposal affects presumably more enterprises, but on the other hand is limited to special legal forms. Also, the due diligence requirements are extended, as are the protected human rights and environmental rights. Finally, the EU Commission's proposal provides for sanctions, fines, measured in relation to turnover. Willingness to cooperate with the European Commission shall be taken into consideration. Also, the EU proposal wants to introduce a new liability for violations of due diligence obligations, not even by the company itself, but also by subsidiaries or even suppliers. It may safely be presumed that this will cause a long and fierce debate. The German Act will come into force as of January 2023, so in a little more than half a year, and we have obviously no experience with it yet. The central requirement for enterprises, that is their management, is the establishment of a risk management system as a necessary prerequisite for the implementation of a reasonable and effective risk management system in order to identify human rights and environmental risks, including the identification of violations along the supply chain and preventing, ending, or minimizing them. Also, the German Act obliges enterprises to establish a complaints procedure and documenting and reporting. It has to be noted that not only executive management boards, but also supervisory boards. In Germany, we have a two-tier system. That is, non-executive directors are obliged by the German Act to control, supervise, and advise on the appropriate implementation of all requirements under the German Act. The German Act is obviously based on the United Nations Guiding Principles on Business and Human Rights of 2011, and on those principles. The following human rights are protected under the German Act. And I avoid now reading all the detailed provisions because some are very obvious, using children for drug trafficking, slavery, etc. Employment of a child of less than 15 years, or if older, that would, according to local law, still be obliged to go to school. Slavery, forced labor, as well as insufficient security standards at the workplace, in particular missing devices for protection against chemicals or other dangerous materials. Unequal treatment, in particular because of nationality or on ethnical criteria. Non-payment of appropriate wages, remunerations. Causing harmful change to soil, water, air pollution, as well as harmful noise emission or excessive water consumption, which may significantly impair the natural basis for the production and preservation of food. And then some others. But those are the sort of core issues that also may be a little problematic. And I will talk about that later. While those protected rights are considered human rights, the German Act also pertains to further environmental rights or obligations. For example, the prohibition to manufacture products with quicksilver, otherwise manufacture or make use of certain chemicals, and deal with, and in particular store and dispose of waste in a way detrimental for the environment, and of course the import or export of dangerous waste. That was the thing that Germany has done, or German companies, for a long time. Waste that we didn't want to have in Germany, we sent to Africa. Often not declared as waste, but as sort of raw material or whatever. broken computers, laptops, etc., then you would see small children there trying to dismantle them, etc. The supply chain, as dealt with by the German Act, means all measures, domestic as well as abroad, that are required to manufacture products from the winning of raw materials to the supply to the final customer. So the full supply chain. Not only the own activities of an enterprise are covered, but also direct as well as indirect suppliers. While the German Act obliges enterprises to certain measures, they do not have to guarantee the success of those. It is sufficient that they prove that they have employed reasonably and in appropriate way the special measures. In particular, the enterprises have to establish an appropriate and effective risk management system. I mentioned that already. Regarding risk that the enterprise itself may cause, even if the risk may not be within the own sphere of commerce. Insofar, many things are not clear. It should be noted that the interest of the employees, including those of the suppliers or others that may be affected, need to be taken into consideration, whatever that means. Clear is that every enterprise subject to the German Act has to identify, evaluate, and prioritize relevant human rights or environmental risks in their own sphere, as well as in their supplier spheres, also in the sphere of indirect suppliers. In practice, this means they have to entertain a so-called risk mapping and update it at least annually. The management is obliged to make a fundamental policy statement about its human rights strategy and communicate it vis-à-vis the employees, the Works Council, an institution that we have in Germany for a long time, its suppliers, and the public at large. Insofar, the minimum requirements are, first, description of the process to fulfill the human rights obligations. Second, describe the human rights and environmental risks. And third, determine the expectations of the enterprise vis-à-vis its employees and suppliers within the supply chain regarding human rights and environment. Further prevention measures have to be employed, including training and coaching in the relevant business areas, and also when selecting suppliers and entering into agreements with them. Well, we see that already for many years in those contracts, these standard clauses where the suppliers have to assure, guarantee, warrant, whatever represent that they are not violating human rights, not using forced child labor, etc., etc. The practical impact may not be as actually wished. Finally, the enterprises have to employ control measures regarding the avoidance of any such stipulations, and that may be the better way to force them to say you have to control it and make sure it's not just lip service, but indeed people stick to it. If an enterprise learns that such human rights or environmental obligations have been violated in its own sphere or in the sphere of a supplier, or if such a violation is imminent, they have to take appropriate measures immediately. Domestically, that is in Germany, these measures have to end the violation. Abroad, they should normally end the violation, whatever that means. The intensity of efforts required depends on the closeness of the enterprise to the violation or imminent violation. With regard to suppliers, an enterprise would have to establish a concept to end such violation or minimize its effects. So in the end, if it's a significant violation, they have to terminate the contract. And we'll come back to that later. Within the enterprise, there has to be a complaint procedure enabling persons, most probably employees, to, as we call it, whistleblow violations or even risks. Such process has to be reviewed at least once every year. Furthermore, the fulfillment of those due diligence obligations have to be documented continuously, pretty much as Louis has already mentioned it for the French situation, and at least annually the enterprise has to report about it. The latest 4 months before the end of the business year, and also on the website of the enterprise for a period of 7 years, accessible for everybody without cost. Enterprises are not required to disclose business secrets. Usually, you would hardly call that a business secret. With regard to the reasonableness and appropriateness of measures to be taken by an enterprise, the following applies. The more an enterprise has the actual power, possibility to influence, the more it is required to use such power. And the more severe a violation is, or maybe, the more efforts an enterprise has to take. Insofar, the business activities in terms of quality and quantity are of relevance, including the size of the enterprise, the number of employees, the turnover, etc. While it is recommended to install a person responsible for the compliance with the human rights obligations, it is not an obligation in itself. However, if such specific person, the compliance person, is determined, the entire management board is not on duty. Otherwise, the whole management board is on duty. So there is an incentive to have one person who is in charge. Persons who claim to be violated in their extraordinary important rights, that is life or health, may sue an enterprise even by having a trade union or a non-governmental organization representing them. In case there's a violation of the due diligence obligations under that law, an enterprise may be fined up to 2% of the average annual turnover, not the profit, the turnover. Enterprises with an annual turnover of more than euro 400 million are affected. Also, they may be excluded from public procurement. Now, a few critical remarks. First of all, the problem with human rights seems to be that originally human rights have been created in France about 250 years ago and then implemented also in the American institution. And to be very short, basically human rights meant life, health, and freedom. As the Americans put it, freedom to pursue happiness. Nowadays, we have gone much further, not only in terms of these European human rights being somehow forced on the whole globe, on each and every country, human rights wherever human beings live, but also extended in terms of scope, up to child labor, forced labor, etc. And my question is, first of all, do we really mean it seriously? Do we really say we cannot have goods supplied from countries where collective bargaining is not allowed? Would then any company in the US or in Europe be allowed to have supplied goods from China? Or, and I'm not talking against these human rights, and discrimination based on nationality, ethnicity, religion. Are we then allowed to buy from Muslim countries where there is discrimination based on religion? Just questions. What I'm even more concerned about is that we have to think it to the very end. If, as it is under the German law, let's say German company, an importer of goods, learns about violations, human rights violations. Let's take the cotton example, forced child labor in Bangladesh. That company would be obliged to seek an end of the violation and finally would have to terminate the contract. Basically, they would have to terminate because they have no means to change the situation in Bangladesh. My question is now, what is the result? Are they still liable towards their customer for not being able to deliver the goods because they can't get them, or the raw material, the cotton? Or would that be an excuse? Pretty much like a force majeure event, let's say under Article 79 of the Convention on the International Sale of Goods, the so-called Vienna Convention of 1980, or would they still be liable? Those are my questions that I find difficult. I'm a business lawyer, and I wonder what are the practical effects and how can we create a situation where we effectively get a better protection of human rights globally, but not to the detriment of companies who are, so to speak, innocent, who cannot do anything about it and would suffer from violations of other people, even governments and legislators abroad. Let me end there. Thank you.
Thanks so much, Hans Christian, and you know, you raised a number of important questions. And maybe if I may make a short comment and maybe ask for free legal advice while I have you here, before we pass on to Louise on the European draft. You raised interesting questions at the end of your presentation, and I like the expression you use, the innocent company, and obviously, you know, that resounds a lot in European history of you know, does the company have a soul? Does it have a moral obligation? Is it the profit and so on? In France, we've just passed a law which is a law on the entreprise à mission. So a company will have specific goals, which include the environment, and there's a lot of activism on part of shareholders, which the board will be responsible for holding management accountable for. And by that process, the company is imposing on itself these rules, and you've stressed repeatedly how blurry or difficultly applicable the German bill is, or law, I should say, to be implemented. And I think the criticism was there also in Louis' comment of the French one, and I think rightfully so. But we are reaching a point where we have a conscious shareholder, and the shareholder holding the management accountable, and the board making sure that what the shareholder expects is there, is also part of the company's sustainability and stability and so on and so forth. And you know, when working with corporates on these issues, the perspective we try to take is really to look at the long term. And you can also look at all these issues as potential risk that you want to avoid. Companies nowadays, as you all know, it fears very often more Twitter than the prosecutor, and the name and shame. And if we're in a situation where, you know, you're involved in child labor, or you've, as you put it very well, used a whole continent as a dustbin to send over all your polluted products. Oh well, we've cut off Hans, or he's left. I'm not responsible for that. So maybe we should just pass on to Louis. But here's a practical question in the line of the comments that were just made, and I'll tell you how we addressed it. It's a company selling insurance around the world, but a lot in Africa. So it's fertilizers basically for farm work and so on, but at a great scale. And they had signed each and every convention you can think of, including child labor. And so we were called in on a separate issue. We carried out an audit, and we listed all these conventions that they happily signed with a big smile, and said, "Well, are you complying with these?" And the answer was, "Of course not." We sell fertilizers in Africa. Every African customer we have at the end works with his family, and then the kids are on the farm. And I said, well, we had this conversation where, okay, you're required by your shareholders, by the fund to which you belong, to sign all these, but in essence, you're misrepresenting. I think that the next step is really one of reporting and transparency, so that you are honestly not misleading or misleading stakeholders, shareholders, and doing an honest reporting. And so what we were able to find is we did put limits. We did get the company involved in local projects, but we didn't sort of give we didn't have them sign something that was just not accurate. And I'd be interested in hearing from others on the panel as to if they've encountered such situations and what they would recommend. But I think really the key to answer the issues that were raised by Hans Christian is be honest in who you are and what you do, and there are ways to work through. If you've intentionally misled, then you lose the trust with the prosecutor, the regulator. I'm currently serving this in two separate World Bank monitorships. You have to build one of the bank, another development bank. You just have to be honest in the relationship you're leading, and a corporate can be honest. Trust me. Yeah. Sorry about that. A bit more than a long comment. I was hoping Christian might come back and react, but I'd love to hear Emily's input on this. But maybe Rui, you can take over, and then we can.
Yes, thank you, Stéphane. Yes, you're right. Hans Christian raised very good questions, and I would hope that we will have time to discuss this more fully. And thank you for your comments, Stéphane. I'd be interested to listen to the comments from Emily on this. But before we get to that, perhaps, as I promised, I will revert to giving you a short presentation on the developments at the EU level, because it is clear from both my earlier presentation on French law and Hans Christian's presentation on the German law that in Europe, at least in the European Union, there was at first a piecemeal, a patchwork approach to having an implementation at the national level of the UN guiding principles. But this approach, which is purely national, is certainly not effective, or not as effective as a EU-wide approach, which we soon realized that it was needed in any case. And as I said earlier, the Belgian also stopped in their national efforts to move a bill into law, and are waiting now for the developments at the EU level. So what are these developments? First, I think that it has to be said that, or reminded our listeners, that viewers, that there is in the European Union a fundamental rights agency which does a very good work, and it has published in October 2020 a report saying that exactly such an integrated European-wide approach would be needed in the field of due diligence. This report was followed by another one by the European Parliament, published in February of 2021. And then the European Parliament voted in March 2021 in favor of requesting the European Commission to prepare a proposal for a draft corporate sustainability due diligence directive. We call this, in short, CS3D, for due diligence directive. CS3D was also requested, or the draft proposal for it was also requested by the EU Council of Ministers on the 3rd of December 2020. So the organs of the European Union had in fact coalesced to move forward on this. Then what happened? The European Commission complied with the requests both from the EU Council and the European Parliament, and published on the 23rd of February this year, 2022, a proposal which will have to be approved both by the EU Council and the European Parliament, and possibly as soon as the end of this year. Now, I will say a few words about what is in this proposed CS3D, but I think that what is important is to understand the time lag, the time schedule on this. Assuming that the directive is actually voted, and at the end of this year, it will come into force. When in fact it has to be transposed into national legislation, because all directives have to be transposed into national legislation by the EU member states. So this whole process could go as long as the end of 2028. So it is expected that all the provisions of the Corporate Sustainability Due Diligence Directive, quite a mouthful, CS3D, will actually become enforceable only in 2028. That is because in the current proposal, the Commission has proposed a stacked approach, a stacked entry into force of the directive. And let me explain this in more detail. First of all, this draft directive is supposed to be an update of the current EU sustainability reporting framework. At the moment, as you may know, there is a non-financial reporting directive which is in force, and it's been already a major progress. So the CS3D is taking this forward, is again moving this at a higher level, if you will. And also, as the Commission underlined in its proposal, this directive is an integral part of the what is called in the European Union the green transition, and this is very important. Also, the number of companies involved is going to be enlarged because the thresholds are lower than in the national laws. From around 12,000 companies that are eligible to be within the scope of the non-financial reporting directive, the CS3D will probably, it is expected, ultimately involve close to 50,000 companies across the European Union. So we're moving to a much larger scope of stakeholders. It's going to introduce more detailed reporting requirements. It will require audited assurance of the information reported. So all of this is going to change. It's a game changer, as Commissioner Reinders, Commissioner for Justice, mentioned when the European Commission presented its proposal. Also, certain large companies will need to have a plan to ensure that their business strategy is compatible with limiting global warming to 1.5 degrees Celsius in line with the Paris Accord. with the Paris Agreement. So as I mentioned, this is part of the green transition. Also, in this proposal for this directive, directors are incentivized to contribute to sustainability and climate change mitigation goals. So all of this is, in fact, goes, in my view, in the right direction. Furthermore, we all know as lawyers that devil is very much, and in fact, quite always in the details. So the Commission was wise enough to already ask a private association, which is called EFRAG, EFRAG, to develop reporting standards for the forthcoming directive. And EFRAG actually just published in May, 2nd of May of this month, beginning of this month, such draft standards for actually implementing the draft directive. So everything comes timely on board, and we can expect more developments during the discussion whether these rules will when the proposal will be discussed at the Council level and the European Parliament level. It can still be modified. At the moment, it is envisaged that the companies that it will apply to are companies that have more than 500 employees and 500 employees and more, and 150 million euros of turnover, worldwide turnover for EU companies, and EU-wide turnover for non-EU companies. And this is the so-called Group 1 companies, to which this directive will be applicable. There is a Group 2 of companies, which is sector specific, which relate to what is called high impact sectors, such as textiles, agriculture, extraction of minerals. Those companies have lower thresholds than the one I just mentioned. So companies that have 250 employees or more and more of 40 million euros of turnover are the so-called Group 2 companies, and they will also fall into the scope of this directive. But it is envisaged that the rules of the directive will apply to these Group 2 companies 2 years later than to the Group 1 companies. I'm sorry, it's a bit complicated, but you understand the process is a stacked process. And at the end of the day, as I said, in hopefully 2028, both Group 1 and Group 2 companies will fall under this within the scope of the directive, which will then be fully in force. That's what I wanted to explain on the developments at the EU level. Stay tuned to this, because it's a moving target. It can still change during the discussions at the European Parliament, but it's unlikely that the end product, the directive as it will be voted, will be very different from the proposal from the European Commission. I'll stop there to leave time to questions and answers. Thank you very much.
Unfortunately, I was cut off the internet and had to move to another place. I'm using now my my iPad, but if you let me in, then I use the regular computer again. But I heard what you said, Louis. I couldn't agree more.
Thank you.
Mm-hmm. Thank you. Thank you, Louis. I mean, really very interesting points. And, how would that fare with, also the countries' legislation, how would this, directive, if it gets approved, will, concordate with the country's legislation. There is, interesting question also, Louis, regarding the enforcement aspect that, Stéphane in some way also mentioned, which is, you mentioned that there had not been many cases, under the French due diligence law. But the question is, would you consider that that's related to the fact that, even a few days before the law entered into force, your constitutional tribunal basically, I guess you could say, took some of the teeth of the teeth of the law in the sense of enforcement, because of the decision that basically upholds the law, but it strikes down proposed civil penalties, for companies that failed to develop a diligence plan. Could you elaborate a little more on that, and maybe explain, if, in your opinion, that has to do or explains in some way the fact that there are not that many cases and might have taken a little bit of the force of the enforcement, to say it some way?
Okay, I'll try to address briefly the two questions. Thank you, Lourdes. Your first question, as I understood it, was really how will the directive affect other countries? Mm-hmm. Very simply, as you all know, the EU is the largest trading bloc in the world, and as with the regulation on the protection of on data protection, general regulation on data protection, it has a worldwide extraterritorial reach. So all players in the industry or platforms that use data basically started complying with RGPD, because it is the norm for the largest trading bloc in the world. And likewise for this directive on corporate sustainability, due diligence, this is going to have a world extraterritorial reach worldwide, because the supply chains are worldwide in scope. I mean, the European companies are buying throughout the world, are importing from the rest of the world, are exporting to the rest of the world, and their supply chain extend throughout the globe. So I think that once we have such corporate sustainability requirements in place, they will necessarily affect a large number of international players, and this is going to have a snowballing effect. That is in fact the game plan, and I think that it is realistic to expect this to happen. It is not pie in the sky. It's really what I think personally is going to happen. So that's my answer to the first question. Now, regarding the second question on the French law, I think you should not overstate what limitation have been introduced by the ruling of the Constitutional Council. Mm-hmm. The Constitutional Council has stricken down a part of the initial some parts of the law as it was voted by both houses of the French Parliament, because they were mixing civil penalties with other considerations which had nothing to do with actually the duty of vigilance. So they were outside the scope or the aim of the law, if you will, and this was quite logical that the Constitutional Council as reviewer of the or guardian of the Constitution would find that the law erred in that respect. But I wouldn't say that it has affected the teeth of the law, which remains as it was envisaged by the legislators. And I think it was and it still is a reasonably effective law, with the provisos that I've mentioned. That is that it is difficult to monitor which companies are actually within the scope of the law, and what the NGOs and trade unions are clamoring for in France, and rightly so, is that the government sets up an agency or a monitoring facility that would make access to data about a number of employees and turnover of companies more easily accessible. And in a way, this is happening already, because the main provider of information in France over companies was a facility linked to the trade and companies registries, a platform which we call Infogreffe. And the government is moving the primary supplier of company information over to the National Institute for Intellectual Property. ENPI will become the main provider, is becoming the main provider of information for on companies in France. So in a way, the complaints of the NGOs and trade unions is already in the course of being addressed by the French government. We're not there yet, but we're moving in the right direction, I think.
Mm-hmm. Thank you very much, Louis. I mean, as Stéphane has heard me say before, I'm a big fan of the fact that French were pioneer with a due diligence law in this regard. But I thought it was important to address that aspect too, so to clarify whether that really affects the impact on enforcement. But another important question, I think, and that will probably give a space for Hans Christian and Emily to comment on that, is if you could compare the sort of scope in terms of the rights, the human rights that are protected under let's say the French due diligence law and the German, that it puts a lot of emphasis also on the environmental impact. What could you say about that? And Emily, maybe if you like to comment about sort of Hans Christian's questions in terms of which rights and how do we categorize them? How do we understand them? And how can we be effective in terms of enforcement also? Thank you.
Yes, you want me to go first because you had put a question back to me.
So. Louis, Hans, and you, I think, could make a nice, contribution.
So I'll just go ahead and go. A couple of things I wanted to say. First of all, I really must clarify that we're not talking about European values. We are talking about international values. And my God, they're, yeah, I won't belabor it too much, but to tell you one little story about my brother-in-law, who, when he was in Munich as the head of design for BMW, could not get a goddamn apartment because there's so much discrimination against Arabs in Germany. So please do not think that Europe has no problems with human rights and the rest of the world is just a cesspit of violators of human rights. That is not the case at all. And some of the most interesting and innovative exercises and activities and experiments on protecting human rights are coming from Latin America, coming from Africa, coming from Asia. The distinction is not some sort of difference in moral fiber, it's levels of economic development, because the level of economic development predicts the vulnerability of those rights holders. And the more vulnerable they are, the more susceptible they are to having their rights violated, which is why you cannot decouple human rights, respect for human rights as a business with the environment in which they're operating, the economic environment, the level of development. So that's why for the ILO, but also for the EU, the third paragraph in that proposal is all about the Sustainable Development Goals, which are nations' commitments to economic and social development working in tandem, because they recognize there is a direct link between the two. So when you are advising your clients on human rights due diligence, you need to understand the economic context in which they're operating, and you need to help them understand ways to contribute to them. Even though I spoke about due diligence being a do no harm approach, it is contextualized in the broader do as much good as you can, recognizing there are not specific targets you have to meet as a company, but the expectation is that you are contributing economically as well. So that means not screening out entire countries because of some violations that happen to have occurred in particular companies, but that does not mean there's a contagion across the entire sector in that country. And try and find the suppliers who are good examples, who could then spread their good practices in that sector locally, just as one concrete example. But the other issue is you need to understand the approaches to due diligence that companies undertake. So now I know you guys are lawyers, you're not particularly interested in how companies actually manage this stuff, but you need to understand just a quick overview of how it actually works in practice so that you can understand and advise your clients appropriately. Now, what companies do, they always start with a risk avoidance framework only. And that's a compliance model where they are more or less substituting for the state in terms of regulating. You look at a code of conduct, they're just referencing basically national law in most respects, but they're substituting for the state. There's a whole body of literature from development economists, from sociologists, from management schools about how this does not work. It doesn't work. It's a huge waste of resources. And what it actually does is take already cost-constrained, thin margin suppliers and actually shaves those margins even more. So having a model that's just about compliance, covering yourself as a company in terms of liability and reputation risk, as Stéphane was pointing out, is the only thing driving that, and it's not effective. The second type of model, there's three altogether. The second type of model is capacity building, and that's where you have buyers that actually work with their suppliers. So Stéphane, to your example of your client who's in fertilizer sales, I can tell you that Syngenta has worked out an extremely effective system for downstream due diligence that includes things like child labor. And they sell a heck of a lot of fertilizer in Africa. And I can maybe put your client in touch with the person. She's actually very kindly helped training. I trained at Bocconi Business School, and she's done, she's shared their example there. I'm sure she'd be willing to talk with your client. But even a compliance model that builds capacity, that educates your business partners and helps them even embed it in a broader productivity improvement system, which is actually the gold standard in due diligence, although much more resource intensive, because it helps that supplier cover the costs and not further shrink their margins that puts the pressure on them in the first place. That is the gold standard to some extent, but it's also limited. And then there's the third approach, which is where the company contributes to the institutions, in particular, industrial relations. So, for example, H&M has a whole program building industrial relations, because the whole objective is to reduce the vulnerability between the worker and the supplier. That makes their rights violations more likely in the first place, and steps back. So it's not always the worker complaining to H&M, but the workers being empowered to be able to have dialogues with the supplier. But equally importantly, the dialogue between the supplier and buyer, because so much, this idea that the companies are these kind of victims of human rights, and they might end up having problems with their commercial contracts because they just are the victims of human rights. Well, that's not true. In fact, they are often the root cause of the human rights violations because of their poor sourcing practices, their lack of capacity in managing supply chains. When I teach at Bocconi, half of my course is devoted not to labor issues, but to how to properly manage a supply chain so you don't put pressure on your supplier in the first place. That is, in turn, putting pressure on them to violate human rights as a way to cope with really crappy lead times, for instance, or asymmetries in flexibility, where you change the order, but they don't get a chance to actually compensate with further lead time to compensate for your changes, things like that. So this idea that there's somehow the buyer and the supplier are completely different entities, and that the actions of the suppliers have nothing to do with the buyers, is so, there is no empirical basis for that whatsoever. And it's not me speaking, it's business school speaking, it's economics department speaking, it's sociology department speaking. I would encourage you to just read reports coming out of a UK-funded initiative called Capturing the Gains, which analyzes in detail across about 10 different disciplines what exactly is the effect of all this due diligence, and what works and what doesn't. And you will understand much more effectively how to advise your clients when you understand what a company actually does, what constraints it faces, but what impacts it also has, and where it can actually affect change. I'll stop there, I'll get off my soapbox, but please don't have such simplistic and reductive approaches as lawyers. I know it's your instinct to simplify, identify liabilities, minimize it for your clients, but that's not the goal here. The goal is, that's part of the goal, but that is not the whole picture. Mm-hmm. And to have the whole picture, you need to have a deeper understanding.
Thank you, Emily. I mean, I hope that if, we can do a simple parallel into do not harm, and also do as much good as you can. Maybe the do not harm, is necessary also, but no enough, no sufficient. And that's the only risk approach to the issue. Whereas do as much good as you can has to do with the capacity building, but also working with your suppliers, because at the end you want to promote economic and social development. So maybe you put yourself on a role to do business, but also advance, human rights, basically. Did we interpret it correctly? Okay, thank you. And I would like to hear now, Louis and Hans Christian, if you have any comment on that, and Stéphane, all feel free to get
Let Hans Christian comment.
With all due respect, all the abstract beliefs, ideologies are all fine. But the question is, as Louis very correctly said, the devil is in the detail. What happens if I have a supplier from China, and we all know there is no collective bargaining there? What is if I have a supplier from Saudi or Iran, and we know there is discrimination on the basis of religion? What is if I have a supplier from Bangladesh, and I know they use child labor, whether it's forced or not? But the thing is, what can I do about it? I can, of course, help by sending people, paying money in order to have a better workplace there, have security systems installed. but collective bargaining powers, I cannot install there. Avoid or abolish discrimination on the basis of religion, I can't do anything about it. So the result will be, and I would, as a member of supervisory boards on which I sit, recommend my management avoid China, avoid Iran, avoid Saudi, whatever, other. Vietnam doesn't have collective bargaining. It's a country that I know very well. So the question is, what do I do in the specific case? And to put it in a larger frame, right now I see that the world is falling apart into at least two different systems. One are the autocratic systems, in particular Russia and China, and what we call or like to call the free world, where you have an understanding of human rights and liberties, etc., etc. Do we really want to cut off all the economic relations? Do we have to compromise? I very much support human rights. I love collective bargaining, of course. I do not want to harm anybody. But what is in the specific case the obligation? What can I do? And as I put it, it's not, my interest is not so much the sanction in case I do not abide by the stipulations. The provision of law. What is if I do? If I do what I'm expected to, namely in the end terminate a contract with a supplier who does not install the right devices, whatever, doesn't pay decent wages, am I excused? Am I exonerated from liability, or am I liable towards my customer? Those are the questions that interest me too. And it is very easy to say lawyers don't see the big picture, whatever. No, we have to respond to that, and the courts will have to respond to it.
Yes.
Please, Emily, please
you.
reply.
Well, you ask, what can you do about it? You need to be clear with your clients about what is a legal impediment and what is a possibility that allows you to violate. So for instance, if you're working in Bolivia where the child, the minimum age is 10 years old, but there's nothing in the law that requires your business partner to hire 10 years old people, you can have in your code of conduct a specification that says we will monitor periodically to ensure that no one under the minimum school leaving age is employed in this enterprise. And that is completely consistent, and there's no reason you have to boycott Bolivia because the minimum age is 10 years old, because your client is able to comply with international labor standards without violating national law. That's one situation. Another situation is where your client maybe cannot abide by international labor standards because the national law is prohibiting that. And the example you gave of Vietnam is an example of that. They have the same system as China, in which there is a national monopoly, state-controlled trade union, which by extension does collective bargaining. And they're in the process of changing that law. Why are they in the process of changing that law? And they've come to the ILO after about 20 years of the ILO encouraging them, please change the law, please change the law. It's really a problem, this law. We're good. It's that's the trade agreement with the European Union, which stipulates they must have freedom of association and they must have collective bargaining. And voila, suddenly Vietnam is really eager to get those two labor issues in line with international labor standards. So that's a case where, no, your client could not source from, without being in compliance or consistent with those the fundamental principles and rights at work. But this is where your client, together with BDA, the German Association of Businesses, can lobby the German government and by extension, Business Europe in the commission, can lobby the commission to insert that in a trade agreement, which they've done, or at least they've supported trade unions in their lobbying efforts, and they've succeeded in changing the law, or at least they're in the process of changing the law in Vietnam. So sometimes your client, you will have to advise to play the long game, that it will take a lot of time and effort on a collective scale to affect change, while at the same time figuring out ways that you're constrained by national law, or at least your business partners are, but to encourage them within the limits of the law to go beyond what is allowed by law to what is in international norms, to be able to be consistent with the UN guiding principles. Mm-hmm. And the UN guiding principles recognize when you hit a wall, like the case of China. So it's not like it's pie in the sky that we're rather naive in the way we operate, but that's where the state pillar comes in. When you hit those walls that are, in legal terms, it's just impossible. But then I would also point out, why are you sourcing there if there's truly an impediment? Like, I don't know, I guess you're sourcing petrol from Saudi Arabia directly instead of in the commodities market. And there's lots of other oil suppliers. So do you really need to source from Saudi Arabia? Because that is an option. Like I said before, we don't encourage boycotting of an entire country based on the bad practices of particular companies that have somehow contaminated and then pose a higher reputation risk for a company doing business in that country. It's simply that they need to do higher levels of due diligence. But there are times when it's not individual companies that are the problem, but the entire structure. And there seems to be no interest in moving on that structure. In which case I would tell you, Hans Christian, to tell your clients, no, really, you should not be operating in that country. I just wanted to distinguish between a government as a problem and particular companies that shouldn't contaminate the other companies.
You're talking politics, I'm talking law.
Thank you very much. I mean, thank you to all of you. This has been a fascinating dialogue, you know, the sort of, and actually we need to continue because there's a lot more development that will come out of this and a lot more to talk about. But unfortunately, the time is our master in this case, and we will have to, close it there. But bottom line is definitely it's not easy. There are a lot of, sort of important goals and commitments, but there are challenges to achieve them. But, nothing that worth achieving, it's easy, isn't it? So we keep working on that. I would like to thank you all. Thank Stéphane for helping us moderate that panel. It was fantastic, really. And I would like also to thank all the organizations that have been part of this Webathon, ABA, AIJA, Law Society of England and Wales, UIA, and our team at the IABA too. Our unprecedented 24-hour Webathon, lawyers across the globe and around the clock for the rule of law, does not stop here. At the top of the hour, we'll go live to Brussels and Kenya virtually to join AIJA and the Kenyan Bar panel discussing the role of law and lawyers in the fight for affordable healthcare for all. No doubt, a very fundamental fight. Thank you and enjoy the program.
Thank you.
Stay well. Thank you.
Thank you, all of you.
Thank you very much. Bye-bye.
Louis, Hans, and Stéphane, thank you. And to all our teams.
Hasta la vista.
Hasta la vista. Merci bien. Danke
Avec plaisir.
schön. Gracias.